Welcome to this overview on the 6th Anti Money Laundering Directive, known as 6 AMLD. The European Union's new Anti Money Laundering Directive should now be transposed into national law in EU members. 6 AMLD is seen as a critical development for the European Union, particularly following a number of major scandals which have ultimately questioned the effectiveness of the anti-money laundering approach in Europe. There are a number of challenges in the wider climate, especially the pandemic, the recent Brexit transition period, and the fallout from a number of major banking scandals. So the implementation of 6 AMLD is particularly interesting because it goes back to the fundamental issues about the nature and the scope of money laundering, as it looks to create some of the most stringent and consistent money laundering offences around the world. Let's start by considering the key changes. Firstly, definition and offences. 6 AMLD builds on the foundation of what the EU defines as money laundering, and this includes the transferring or conversion of property, knowing that it is the product of criminal activity, particularly whether an attempt to hide or disguise its illicit origin, or if that's an assist to anybody involved in the legal consequences to evade their particular actions. Hiding or the disguise of the true nature, the source, whether that's the disposition or the movement, with rights to respect of ownership of the property, knowing that it came from criminal activity. The acquisition, the possession, or the use of the property, knowing at the time when it's received that it had come from criminal activity. Another big change with 6 AMLD is that it's actually defined 22 predicate offences that constitute money laundering. This is interesting because this is now creating an EU-wide standard. Now, these offences include the participation in organised crime groups or racketeering, human trafficking and migrant smuggling, sexual exploitation, the illicit trafficking in narcotics, psychotropic substances or arms trafficking, trafficking in stolen goods, corruption, murder and grievous bodily harm, fraud, counterfeiting such as currency or the piracy of products, environmental crimes, kidnap and hostage taking, robbery and theft, smuggling, tax crimes, extortion, forgery, piracy, cybercrime, terrorism, and insider trading and market manipulation. Another crucial area is around liability. Under the current legislation, only individuals can be punished for money laundering, but 6 AMLD extends that liability from a natural person, like you or I, to legal persons, such as companies and business partnerships. Punishments. Now, 6 AMLD has brought in more punishing measures for those convicted of money laundering, which includes an increase in the maximum prison sentence, plus other measures such as fines, professional disqualifications, and disbarments. Corporate offences are now within that remit, and these are impacted especially around things such as closure of businesses, freezing or confiscation exclusions, bans on conducting businesses in the future. Another key focus on 6 AMLD was the cooperation. Now, member states are required to improve levels of international cooperation in investigation and prosecution of cross-border money laundering cases. And that's really looking at that vulnerability, how criminals look to exploit those boundaries in order to move their proceeds of their crime. Let's consider a timeline of these events then pertaining to 6 AMLD. Now, on the 23rd of October 2018, the 6 AMLD was published into the EU official journal. As part of that journal and that publishment, the 3rd of December 2020 was proposed as the deadline for transposition into national law. And we know that deadline has now passed, meaning those EU members now must have 6 AMLD transposed into their respective law. The 3rd of June 2021 is the deadline for this implementation by obligated businesses. So, what do we need to do? The introduction of the new directive is going to impose a greater requirement to comply and administer these requirements for these firms. So firms really need to consider their enterprise-wide risk assessment, and at this point I should stress that there will not be a one solution that fits all. So ensure that the assessment is appropriate to the size, the scope and the risk of your respective firm. Final thought then. Consider the reputational damage that your firm may face for non-compliance to 6 AMLD. As we've seen with 5 AMLD, the 5th Money Laundering Directive, many countries hadn't complied with some of those requirements, and you may have seen publications around poor beneficial ownership registers. So in light of this, regulators are going to be really interested in how and when firms are able to sufficiently display that they have implemented those directives as part of their risk assessments to avoid any failings. Remember, governance is key. Businesses need to ensure that the robust mechanisms for accountability on anti-money laundering are in place. I hope you've enjoyed this video. Thank you for your time.